Good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmera, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for Understanding Public Charge, a practical guide for advocates working with immigrants. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded. If you registered, you're going to receive a copy of the recording via email from Zoom within 24 hours. If you don't see that email, I'm also going to drop my email into the chat just in case. Feel free to reach out if you need anything. The training was approved by the Florida Bar for one General CLE and one Immigration and Nationality Law Certification credit. I'm going to announce the CLE code towards the end of the webinar. I will also drop it into the chat, and the CLE code information will also be included in the email that goes out from Zoom. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. The training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I'm also going to drop the link to their website and how to join into the chat as well. And final piece of housekeeping announcements. If you have questions during the presentation, feel free to use the Q&A feature. You might want to drop the question in the chat. We'll do our best to address your question. If for whatever reason we miss it during the presentation, we'll make sure to address all remaining questions towards the end. So that was my final piece of housekeeping announcements. And with that said, it's my pleasure to introduce our speaker today, Ronnie Graham. Ronnie is a dedicated advocate committed to advancing justice through law, business, and community service. With a background in criminal defense and corporate law, he has served as a public defender and as an associate at Ackerman LLP, gaining extensive experience in litigation and advocacy. Currently, Ronnie is the Pro Bono Director at the Florida Health Justice Project, where he leads initiatives to expand access to legal representation for underserved communities. Ronnie holds a Bachelor of Science in Political Science and a Master of Business Administration from FAMU, and is a proud graduate of the University of Miami School of Law. His passion for health justice was shaped by his work as a field coordinator of research at the University of Florida, where he investigated food deserts and barriers to nutritious food access for SNAP recipients in Tallahassee. Beyond his legal work, Ronnie is deeply involved in professional and civic organizations. He currently serves as the co-chair of the D.W. Perkins Bar Association Pro Bono Committee and vice chair of the Judicial Relations Committee for the Jacksonville Bar Association. Previously, he served as the vice chair of the Jacksonville Bar Association's Diversity and Inclusion Committee and was an associate member of the Chester Biddle Inn of Court. Ronnie is also a proud member of Alpha Phi Alpha fraternity and remains actively engaged in efforts to expand pro bono legal services, judicial relations, and policy advocacy to create a more just and equitable legal system. So, without further ado, I'm pleased to pass it over to Ronnie. Ronnie, the floor is yours.
Thank you so much, Mr. Palmer. And it is just a quick note to myself to shorten that bio up very much. And I just want to apologize in advance to everyone for my voice. I took my kids to Legoland this past weekend for Mother's Day as well with my wife. Happy belated Mother's Day to all the mothers out there. But I did have a little bit too much fun. So if at any point you can hear me or need me to repeat myself, feel free. Ronnie Graham, I am the Pro Bono Director for the Florida Health Justice Project. And we have many great partners, and one of our great partners is Protecting Immigrant Families, which is a national organization that focuses on advocating for immigrant families, including making sure that they get all of the benefits that they can and that they're not afraid to do so. So that's exactly what today's training will be on. As you all may know, with the legislation and with the administration change, many things are subject to change according to this public benefits doctrine that we're about to go over. However, this is the most up-to-date information. And then if we have any more information, we can send it out to you all at a different time. So first, I just want to talk about how the Herlinda project came about. Back in 2018, a leaked draft executive order by the Trump administration detailed plans to put green card applications at risk if a person used a wide range of federal programs. While the proposal would have affected only a small segment of immigrants, there was obviously a chilling effect that spread across the entire immigrant population. Herlinda Abrera was a health enrollment eligibility manager working in Texas during this time and saw that many of her own clients were hesitant to enroll or renew their benefits for fear of immigration consequences. She realized that many of these clients were being advised by well meaning immigration attorneys to not utilize the benefits in order to keep their immigration options open. So, what she did, she began to reach out to those lawyers to give them accurate information about which are the relevant programs. And she did this in a number of ways, including writing a letter that the clients can provide actually to their attorneys. You know, usually us as attorneys, we provide letters to our clients to provide to the doctors or different things like this. This is her as a social worker seeing the need to educate us. And that's really why we're here today. Is in order to educate you all, many of you all who already practice in this area, but to just give you all the confidence with the updated knowledge to say, hey, this is what you can actually enroll in, and here are the things that you should avoid. As opposed to what we've been finding is that a lot of um, people in the legal community are just advising to just avoid all of the programs. And, you know, it is coming from a good place, obviously trying to protect the client from potential consequences. However, it could be causing the client and their children to forego essential public benefits. So as you see here on the screen, um, here is the letter that she created. Well, you don't actually see the letter, you see the QR code. It's in English and it's in Spanish. Feel free to have that letter and to download it. But as a result of her efforts, she saw that her in her community health center, they saw no significant drop in enrollments, but everywhere else, they did see a drop in enrollment. So why does the public charge matter? And this is the public charge doctrine. As I said, many individuals and families are still foregoing critical public benefits for fear of the immigration consequences. In 2022, 1 in 6 adults in immigrant families avoided non-cash government benefits in the past year because of green card concerns. And another one is that, you know, the immigrant population, they trust their practitioners a lot to help them understand what's safe or what's not safe to use. So this training is actually for us today to make sure we're advising them and making sure that we get that number down to zero. We don't want anyone to be able to forego any of the benefits that they are entitled to. So what will we learn in today's training? And today we will learn what factors determine whether a person with a specific immigrant status is eligible for public benefits. Number two, we'll learn in what circumstances would a person be subject to the public charge test. And then number three, which public benefits your clients may be receiving that are considered in the public charge test. Now, as you know, there are several different special immigrant status out there. And this PowerPoint that I have pulled up, we're specifically going over the T and U non-immigrants. But once I get done with this one, I will quickly also go into some of the other specific immigrant statuses as well, such as VAWA, such as TNU, such as refugee, asylee, as well. So you're going to get a good view over how all of them apply. When I pull up the other PowerPoint presentations, I'm going to skip to probably to the most relevant portions of the PowerPoint presentations because many of them contain similar things at the beginning. So just a quick note following the 2024 election, this does say update as of December 2020, December 23, 2024, but I can confirm that this PowerPoint presentation is still relevant today and things have not changed as of yet. No changes to public charge policy or federal public benefits eligibility have taken place yet. So people in immigrant families should continue to use the health, food, and housing assistance programs for which they are eligible. So that's a little clue right there as to what programs individuals in special immigrant status may be eligible for. Already, we see that they may be eligible for health, food, and housing. And here's a big one that I want you all to remember. If you all can only remember one thing from this whole thing, well, let's say two things. Here's one of the two things. Number one is there's an awesome website out there called keepyourbenefits.org. They have it in English. They have it in Spanish. I believe they have it in Mandarin. They have it. They're continuously adding different languages to it, but it's called keepyourbenefits.org. And this is where individuals as well as practitioners can go on the website, enter the information such as, hey, they're this special immigrant status. These are the benefits they want to use. And then the website will inform you based off of the latest updates whether or not they will be subject to the public charge document or not. So that is one of the two things that I want you to take away from this presentation, if nothing else. One is keepyourbenefits.org. Super awesome website. I encourage you all to use it. Um, and it is updated by practitioners such as yourself who practice in this area, so it's always continuously updated. So before we dive in, it's important to understand that each state has its own eligibility requirements for public benefits. Um, Also, as you all may know, clients may have multiple immigration applications in progress. As we go through the training, we'll see why we need to pay special attention if they do. And the second biggest thing that I want you to take away, and we're already hitting it right off right away, government assistance for healthcare, food, and housing does not count towards the public charge test currently for anyone in those special immigrant status that we're talking about. Now, this is not just anyone who is just in America. They have to have some type of pending application for one of the special statuses that we're talking about. But generally, they are allowed to receive assistance for healthcare, food, and housing, and should not be worried about the public charge test. We'll go into what the public charge test is actually really looking at. All right. Now, as I said, each state has its own public benefits eligibility criteria, and then there's the public charge criteria. Protected immigrant families got with each state in order to have these training. FHJP is the Florida training. So today I'll be letting you know some of the public benefits eligibility criteria for Florida and some of the things that Florida may do differently than uh, than the federal requirements, such as the 5-year ban. Whether or not Florida is more lenient than the federal side of things. And here's a quick clue: Florida is not more lenient than federal. That's not a surprise, as Florida has not decided to expand Medicaid, as we know. So, Florida, whatever the federal guidelines is, Florida pretty much sticks by that. So, but for public benefits, They define the circumstances which someone would access various public benefits. It's administered by state and local health human agencies. It varies by state. In Florida, we know that most public benefits are regulated by the Department of Children and Family, DCF, or ACA, the Agency for Healthcare Administration. And it's based off of income, immigration status, and other factors. So if if a person is qualified to use the public charge status based off of their immigrant, their special immigrant status, however, they don't meet the income requirements, then they still won't be able to get the public benefits. So it takes two things. It takes the you being eligible based off of the income, your assets, how many people you have in a family, your age and demographic, different things like that, as well as the public charge document. The public charge criteria is what is being used by federal officials to determine whether someone can get immigration benefits, such as a green card. That is actually regulated by the Department of Homeland Security or Department of State, the same individuals who are over ICE. So here are some of the different things you may hear throughout this training. Number one is qualified immigrant, which is a non-citizen who meets certain criteria to be eligible for federal programs. Lawfully residing, lawfully present, permanently residing under the color of law, and the 5 year ban. The 5 year ban is very important. The 5 year ban bar, not ban, excuse me. The 5 year bar is a 5 year period during which many individuals are required to maintain qualified immigrant status in the United States before being able to access public benefits. There are some states who have lowered this requirement for state benefits. Again, and unfortunately, Florida is not one of those states. So that is something else we need to be looking out for, right? Is someone in the special immigrant status? That's step one. Number two, do they even qualify for public benefits based off of their income, assets, and other factors that DCF may determine? And then number three, the big one, have they gone through that 5 year bar? Now, very, 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 very important slide. Please take a screenshot of this slide. Move me out of the way if you need to. This is uh this is going to apply. This page is really for T T visa holders and U visa holders, but the left side of the slide, to the left of it, with the shark to the left, these are the benefits that are usually always going to be considered part of the public charge test. Now, there are certain statuses that can use these two benefits, which are cash assistance and long term care paid for by the government. Those are the two that, if your client wants to use it, you need to have your ears need to perk up and your eyes need to think like, okay, maybe they might be subject to the public charge test. As we said, housing, food, and housing, food, and let's go back. Excuse me. Housing, food, and health is not really one of the main concerns for most of them. However, cash assistance such as using TNAF, SSI, SSDI, long-term care paid for by the government, such as them actually have to go into a nursing home or a psychiatric hospital paid for by the government, will be subject to the public charge test. Now let's get to the right side of this one. Now, because like I said, this varies based off of special immigrant status. So for T visa holders who already have a prima facie case determination, on a T visa application. This is important. Just because you apply don't mean that you already have a facie case determination. But if they do, they are actually eligible for both cash assistance, for income maintenance, and for long-term care paid for by the government. So T visa holders are very special in that. There's another special status that we'll talk about that also they can have cash assistance and long-term care paid for by the government, but it's rare. But T visa holders are. Now, here's another big one that I want to you to remember or just to think about. So let's revise my, if you can only take two things away, let's take three now, because this is important. Super duper important. Children's use of the benefits never count towards the public charge test for the parent, including even if that parent is receiving the benefits on behalf of the child. So that includes nutrition programs, health coverage, cash assistance, and housing. And so what that'll look like is obviously if the child is eligible for cash assistance, right? And they specifically apply for the child and not themselves, obviously the child isn't going to get the check or the direct deposit. The parent would, the mother or the father or whoever is the custodial over the child would get it. And they would never have to worry about whether or not it will affect them themselves when they apply for a green card. It's only when the actual person who is receiving or who is applying for the green card is receiving the benefits themselves directly, not not in this situation where they're just being a custodian for their child, but when they are receiving it directly will the public charge test. So what is the key takeaway from this? If you are dealing with an individual who is in a special immigrant status and they have children, advise them to place their child in these public benefits if they're eligible, right, by income, and if they need it, feel free to go use it. Children should not have to worry about this. They should be able to get the nutrition program, the health coverage, the cash assistance, and the housing. So here are three steps to determine whether a public charge test applies to an individual. Number one is the individual submitting an immigration application. If no, then no, the public charge test don't apply that time. If yes, are they applying for a family-based green card? If it's no, the public charge test don't apply. If it's yes, if they are applying for a family-based green card, so that's the one we need to be looking out for. An application for a family-based green card, then we need to go to step two, which is who is receiving the benefits. As we just went over to in the previous slide, if it's the children, or if it's their grandma or someone that they're taking care of it, but it's not themselves, then no, they it will not be considered. But if they are receiving any type of benefits, we need to go to step three, which is are they receiving of all the benefits, right? Food, housing, healthcare, are they specifically receiving cash assistance for income maintenance or are they in long-term care at the government expense? If it's no, um, they are subject to the public charge test, but but those benefits will not be considered. And if yes, um, if they are using cash assistance, then it will be considered as a part of the public charge assessment. And while no single factor is determinative, we are living in a climate to where and there are questions over due process and things like that. I'm not going to get into that. However, it is likely that individuals will be denied if they're using. So it's very, very got to be very, very careful and advise our clients not to use any type of cash assistance or learned long-term care at the government expense if they can absolutely help it. It says your state may. It seems like I got the wrong PowerPoint because I edited this one. I what I'll do is I'll send over some benefits links because what I did was I put in some DCF benefit links in there for you all to see if they're eligible. But this is a great time to plug in the Florida Health Justice Project. This is what literally we do. We handle Medicaid cases, Medicaid termination cases, Medicaid coverage denial. So if you all ever have any type of questions, feel free to reach out to us, and our excellent attorneys who have way more knowledge than me can kind of guide you. But moving forward, we're going to look at specifically how TNU visa holders might interact with public benefits and the public charge along their immigration journey. Step one, when they thinking about applying, right? The public charge tests do not apply at that time, and they would be ineligible for federal funded cash assistance and ineligible for federally funded long-term care. So this is um, when they're thinking about applying and when they apply for the TNU non-immigrant status. Now, this may be confusing you because you just said because I just told you that T visa holders are eligible for cash assistance and long-term care. However, remember, I said it's only when um, they have been approved for a prima facie case determination already. So even so now they've actually applied, they're pending the N-14 form and they're pending the I-918 form for the U immigrant status. Um, the public charge test does not apply, but they will still be ineligible for the cash assistance. Once then that they are actually approved in or once they are actually approved for the prima facie case, then T visa holders would be eligible for the cash assistance, but U visa holders would still be ineligible for the cash assistance. T U visa holders would also be eligible for the long-term care, but the U visa holders generally would not be eligible for the long-term care. However, they if they are pregnant or they have children, they may be eligible for health coverage in certain states. Florida is one of the states. However, the 5-year bar still applies. So still would have to wait the 5 years. And then lastly, once they are T. This is specifically for T visa holders when they actually are applying for a green card through their status, because as you know, or you may not know, they can apply for a green card through a different status. And this is a big key that I want to say. If someone has a special immigrant status, you want them to apply for a green card through that status most of the time to avoid any problem with the public charge documents. And some of the other special statuses, we will see why that's so important. However, while the T visa holders, this is not applied to you, visa holder, while the T visa holders are applying through green card, they would still be eligible for the federally funded cash assistance as well as the long-term care. This is unlike the U visa holders, which would still be ineligible for the cash assistance while applying for the green card status, but they may be allowed to get certain health care coverage if pregnant. And as we said, the children are always fine. So here's a quick quiz. And I just would like you all to just put it in the chat if you all can, if you want to participate. I'm just kind of going over this one, the T and U visa holders to see if you all kind of caught on to the public charge document doctrine and how it applies to them. So Tina was issued a T non-immigrant status, and after living continuously in the U.S. for 3 years, is now eligible to apply for her green card based on her current status. Is Tina subject to the public charge test? Yes, no, or it depends. Please, and I don't know if you all can put it in the chat, but if you wanted to participate, put it in the chat. Put your answer yes, no, or it depends. Give you about 10 seconds. Okay, got a couple no's. Got a couple no's. Got a lot of no's. That's awesome. And thank you, Laura, Michelle, Christy, Emily, Veronica, Jeff, Angelica, Andrea, everybody for participating. So the correct answer is no. Great job. So nobody said yes, so that's awesome. No, as a T non-immigrant applying for green card based on being a T non-immigrant, Tina is not subject to the public charge. So as you all know, like if you all passed the bar exam, right? This sounds kind of like a legal question or a legal from the bar exam, the answer at least, right? No, because she is applying based on being a T non-immigrant. If she was applying for based off of any other status or outside of it, then it potentially could have applied. But in this case, no. Uh, it, Tina is not subject to the public charge test. Moving forward, Arena had a T non-immigrant status that has lapsed. So it lapsed. She is now applying for a green card through a family petition. Could Irina be subject to the public charge test under these circumstances? I would like you all to participate again. I'll give you all about 15 seconds. She had a status, it's lapsed. Now she's applying for a green card through the family petition, not as a T non-immigrant status. All right, got the first answer in, and it is a yes. I'm getting a bunch of other yeses. Awesome, awesome. So the correct answer is actually yes. So you are on the ball. As a T visa holder, Irina could be subject to the test when applying for a green card if her T non-immigrant status has lapsed and she is applying through family petition. In this case, if she had used uh, cash assistance or for income maintenance or long-term care, she might it might be considered as a public as a it might be considered in the public charge test. That might um, in recent developments is a strong may at the very least. I want to say will, but it's a very strong may. All right, gonna give y'all a multiple choice question here. So her she had a T immigrant status, is now lapsed. Now she's applying for a green card through her family petition. Her son Igor has been enrolled in CHIP for several years. Will her son's use of benefits be considered in Irina's public charge determination? Why or why not? Um, is it A, no, children's use of benefits never count towards appearance public charge test? Is it B, no, because CHIP is not a benefit that counts in public charge test? And C, both A and B. And I want to give you all just a little clue who may not be familiar with Medicaid. CHIP is just a form of Medicaid. It's specific for children. So it is a health care. So I see the answers are already coming in. I have one B. I have some C, 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 C. I'm getting a bunch of C. And the correct answer is actually C. So whoever said B, I won't say your name. You were right. N- CHIP is not a benefit that counts towards the public charge test because it is a healthcare benefit. So you are actually right. But it is also A because children use of the benefits never count towards the parents and the public charge test. This is the keepyourbenefits.org website that I told you about that you can look up by the client status. Feel free to pull out your phone, use that QR code. It's just going to take you to the keepyourbenefits.org site. But that is something that you can use. And as you see, you can just find out about someone who has, and then you just see are they in asylee, refugee status, are they a citizens, the DACA, they have green card, special immigrant status, which we'll cover today as well, tier U status, which we really just got done covering, and one that, okay, yeah, VAWA, which we will cover today as well. And there are state specific pages. Florida is one of the states that have a state specific page for you to learn more about it. And as you see, they have it currently in English, Spanish, and Mandarin. And they're actively trying to expand. One that I actually told them here in Florida that we see a lot of as well is um, we see a lot of Haitian immigrants here. We see a lot of Jamaican immigrants here. A lot of people from the Caribbeans. Obviously, we see a lot of the Spanish speaking population as well. And I think the Spanish, I'm not sure which actual like country of origin the Spanish is. I know because I took like 2 years of Spanish in high school, and I know that different Spanish, different countries speak a little different. And however, hopefully you all have someone on your team that may be able to decipher if there's any gaps in the Spanish. So that concludes the T and U visa holders status. If you give me just 1 second, I am going to pull up the special immigrant status.
Sounds good. Well, Ronnie pulls it up if anybody has any questions. I've been dropping some of these resources into the chat, so feel free to poke around. I will include all these links in the email that also goes out.
And thank you all so much for your participation. It helps me. I like the webinar view, but then sometimes I don't like it because I feel like I'm up here just talking to myself. You all have been such a great crowd, so I don't feel like that at all. So next, we're gonna get into the special immigrant juveniles status because it changes slightly from the T and U visa holders. As I said, most of this beginning of the PowerPoint is the same. So I'm just gonna skip to the relevant portion. All right, here. Now again, same thing. Children use of benefits never count. Uh-uh. Okay, sorry. Back. Children use children use of the benefits never count. However, cash assistance and long-term care are the ones we need to be looking out for. So for special immigrant juveniles, they are ineligible for federal cash assistance and ineligible for long-term care. Excuse me. So they're unlike the T user visa holders who are eligible once they get to prima facie determination in their case. Special immigrant juveniles are not eligible. Of course, the public charge test never counts towards the children. This is the same three-step process, though. I'll go over it one more time in the next PowerPoint. I won't go over it because it's the same three-step process for each of them. Number one, are they submitting an application? If they're not submitting an application, then the public charge test doesn't apply this time. If yes, we want to see if they're applying for a family-based green card. If no, the public charge test don't apply. If yes, we need to go to step two. And then who's receiving it? Is it actually the special immigrant juvenile in this case, or is it just or is it someone else? And then number three, are they receiving cash assistance or long-term care? Again, I'll provide you all with more special the links to the DCF website for the rules. But I just want to take a look at how the special immigrant juveniles might interact with the public charge test, and then we'll follow along with the immigration journey, and then there'll be a couple questions at the end to see if you all capture this status and how it applies as well. So once they're applying for the special immigrant status, the I-360, while they're filing for it, it says that they're not ineligible. They are not eligible for cash assistance. It says that they may be eligible for the long-term care in some states. Florida is not one of those states. Now they're actually applying here. Again, this is just showing that um, they would not be eligible for the federal cash, but they would be eligible for long-term care if they actually have the status. So once they're actually approved, they would be ineligible for the cash assistance, but they would be still eligible for the long-term care. So this is slightly different from the T visa holders and a little bit better than the U visa holders, where U visa holders who are actually approved when they get to the point of applying through the green card through their status, they are not eligible for cash assistance or the long-term care. But here it seems that they would be eligible for the special immigrant juvenile would be eligible for the long-term care. Okay, so a little quiz. Felipe has a pending I-360 petition for the special immigrant juvenile status. I'm gonna just start saying SIJ. If while awaiting approval on his petition, he utilizes Medicaid, would he be subject to a public charge test when he later applies for LPR as an approved special immigrant juvenile? Yes, no, or it depends. If you could please answer in the
Ronnie, while we
this.
wait for answers, we do have a question in the Q&A. So I'm gonna go ahead and read that one out loud while we see the answers in the chat. The question is, for those seeking a special immigrant visa as promised to them when they began assistance for the U.S. military, translators for Afghanistan, for instance, are there any differentiating factors, or is it the same for all special immigrant visas regardless of reason?
To my knowledge, it is the same regardless of reason. If you could please, can you document all the questions, and then what I'll do is I will get with my national partners, and then I can follow up with that. But to my knowledge, no. And we've actually been seeing terrible circumstances. I've been trying to stay off of social media and TikTok and stuff because it's just absolutely terrible. But I've seen instances where actual military veterans are being told to self-deport right now. So terrible situation. So the answer is no. And I think many of you got that right. If he later applies for the green card based off his status, he will not face the public charge test. However, if he decides to apply for a green card through the family-based system, he could face a public charge test. However, as we said, Medicaid, which is health care, right, is never considered in the public charge test, so he'll be fine. But this is something I really want y'all to really catch on to, right? If he if he would have been completely fine, regardless if he had just applied through being through SIJ status. However, because he decided to apply to the family-based system, he could have faced it. But because he only used Medicaid as opposed to the long, as opposed to the cash assistance, he's fine because health care is never considered. Lashima it has been granted SIJ status several years ago, and now she's adjusting her status to obtain a green card. In which circumstances might she be subject to a public charge test? Is it A, she applies to the family-based system instead of through adjusting through the SIJ system, and she receives cash assistance for income maintenance? If you all have been listening, that sounds like it should have perked your ears a little bit. Is it B? She's applies through the SIJ system and has been utilized in long-term care. Long-term care. Is it C? She applies through family-based system and has not been utilized in any public benefits. And I think I see some answers coming in. A. Very good. The answer is actually A and C because this is one of those tricky law school exam ones, right? We're not asking will the test actually hurt her. We're just asking would she be subject to it. So in both circumstances, in A and C, she would be subject to the test. And C, she would be subject to it because she's applying through the family-based system, so she doesn't have any type of special immigrant status, and to which they would not be looking at the public charge. But since she hasn't been utilized in any public benefits, she will be fine in this situation. Now, in A, we know the answer to why A. That's what we've been going over this whole time. So I'm glad everyone caught on to A. It's because she adjusted it to the family based and she was receiving cash assistance for income maintenance. So very likely the public charge doctrine would apply to her and could very well prevent her from being able to obtain a green card without a lot of trouble. And that's essentially what this says as well. And it is just a good point to to point out is that the public charge test does consider a wide range of factors, not just the use of the public benefits. I've said that now. This is my second time saying that. We're just covering the use of public benefit side of the public charge doctrine. I am not qualified to talk on the other wide range of factors. I am qualified based off of them training me on this subject to talk to you about the use of public benefits. Again is the keepyourbenefits.org. And I see I have about 10 minutes left. So I'm going to do the same thing I'm going to try to get through two more, but it's going to be a little bit faster. One is one we see commonly in the state. I'm very familiar with, and I've had this training with some other legal aid organizations throughout the state, and this is one that practitioners commonly come across. And these are individuals who are victims of some type of um, domestic, and they receive this status. Okay, so just going back, one thing, right, we want to remember is government assistance for healthcare, housing, and food does not count, right? Number two that we want to remember is that children's use of benefits never count towards the actual person. Number three, what we want to take home is that the cash assistance and the long-term care use of public benefits are the ones that directly apply to the public benefits and the ones that we need to be looking out for, especially. Now, just because um, they are a part of the public charge set, don't mean that in every circumstance that in every special immigrant status they actually apply. So, for example, individuals who have a VAWA self petition and have set forth a prima facie case, right, and have met the 5 year bar, let's not forget about the 5 year bar, are eligible, are fully eligible for cash assistance and long term care for use for themselves. And they can still apply for benefits for the children, and those benefits for the children um, won't count against them, but they are actually eligible. Of course, one of the big takeaway, sign the kids up if they need it. As I said, I'm not going to go through the 3 steps this time, but these are the 3 steps again. Here's one that actually has the updated links on it. Finally a PowerPoint that don't want to embarrass me. As you can see, I listed off the DCF websites and some Medicaid information. That's just more so about actually becoming eligible for benefits, period. It's not about public charge, it's about period. Like, do they meet income? Do they meet the basic things in order to be eligible for Medicaid or any other assistance? So when they are actually submitting, so the public charge test does not apply to individuals who are submitting the application. So while they are submitting and pending the application, they can use it. They are eligible for cash assistance as well as long-term care. They are still subject to that 5 year waiting period, which hurts a lot of people. Then once they get the prima facie determination, the public charge test will still not apply to them, and they will still be eligible for the cash assistance and long-term care, subject to the 5 year waiting period. And this follows them all the way through applying for a green card. The public charge test will not affect them as long as they're applying for the green card through their VAWA status. Don't highly unless you all know some reason why they should be applying through a different status. If you know your clients are using some type of public benefits, have them apply for their green card status through their status. And it's actually be more favorable to them anyways. So Anais received a notice of prima facie determination for a VAWA self-petition and started using SNAP, which is food stamps. Will her use of SNAP be considered in the public charge test when she applies to a green card for a VAWA status? Just because we're short on time, I'm gonna just kind of skip through. The answer is no, because she already has the prima facie determination for VAWA, and she's using SNAP, which is food assistance, which wouldn't have counted anyways. Um, so she's already a qualified immigrant. So the public charge test will not apply to her in this situation. Arcelius is an approved VAWA self-petitioner who has been living in Section 8 housing and utilizing cash assistance for income maintenance. If she later chooses to apply for a green card through her VAWA status, will her use of these benefits implicate the public charge? So she's using housing and she's using cash assistance. Housing is fine as long as it's not long-term care, right? The housing is the one we need to be like, excuse me, the cash assistance is the one we need to be looking out for. But because she has her VAWA status, she should be actually be eligible. So none of these benefits should implicate her, and that's exactly what the quiz is saying. No. If she applies for her green card through a family petition instead of her VAWA status, what benefits could be considered in her public charge test? Is it A, Section 8 housing because it's subsidized by the federal government? Is it B, cash assistance for income maintenance? Is it C, both A and B? Or is it D, neither, since approved VAWA self-petition or adjusting through family-based petition are exempt from the public charge test? I can tell you right now, it's not D. The correct answer is actually B. Try to trick you a little bit because the whole subsidized by the federal government, the Section 8 housing, that's fine. Housing is fine. It's the long-term care. It's like if they actually need to go like to a nursing home, and so the government is paying not only for them to live there, but also paying for the nurses and stuff. So it's B. The only benefits that will be considered is the cash assistance, and that the only reason for it, right, is because she decided to apply through the family petition instead of the VAWA status. So that's super terrible. She would be qualified if she just applied through the VAWA status. So that's a big key takeaway. I think that's gonna be number four. Remember four things now. The fourth thing is if they have a special immigrant status, when they apply for the green card, advise your clients to apply through that status and not through anything else. Again, keepyourbenefits.org. And we do have only 2 minutes left. So what I'll do is I will compile all of the PowerPoint presentations and give it to Mr. Palmer to be able to send out to you all. The only one we didn't cover that I wanted to get to potentially was the asylum slash refugee status, which we know in Florida that is common as well, or at least for people to apply. So I'll send that as well. And so just here are my four takeaways. Number one, children use of benefits never apply. Them children need to be using it. Number two is that housing, food, nutrition never apply to the public charge test. Number three, the only ones that really ever apply to the public charge test is the cash assistance and the long-term care. And then number four, if they have received a special immigrant status, um, advise your clients to apply for the green card through that status as opposed through just a general family um, status. So thank you all so much.
Ronnie, there is a question that was relevant
Okay.
to like maybe like 2 slides ago when you were using the subsidized housing and cash maintenance example. The question was whether the person had to wait 5 years. Uh,
So generally, unless the state has an exception, yes, you still gotta wait 5 years for the use of public benefits. The children you'll be fine to apply for, right, if they're applying for the children, but generally if the individual wants to receive any of the benefits, they would have to wait the 5 years. And please send me that question too, because like I said, I am not the nationwide expert on this, but I'm going to get back to them, and then if the answer differs for any reason, then I'll give you all an updated answer.
Sounds good. I dropped the CLE code information into the chat. I'm going to read it out loud as well. As I said earlier, this session was approved for one general CLE and one immigration and nationality law. certification credit. The code is 250479N. I'll make sure to include that code in the materials. The link to the materials folder right now is going to be empty, but as soon as Ronnie sends me all these materials, I'll make sure to upload them there. And I'll create a Google Doc where I'll compile all these links that we have been mentioning. I'll document the questions that were asked during the presentation. And if for whatever reason we need to update answers, we'll make sure to do that right there. So I know we're 1 minute past our time. I see a lot of thank yous in the chat. I want to thank everybody for joining us here today. Thank you, Ronnie, for an amazing presentation. Any last remarks?
So I would just say I was about to upload all the PowerPoints. It says I don't have permission, but you all feel free to check that link that Mr. Palmer put out there, and soon, within like I guess in the next 10 minutes or so, I have all the PowerPoint presentations up. And thank you all so much. I received a lot of thank yous in the chat, but thank you all. Very, very timely and important topic that we're talking about. So thank you for taking out the time to come listen to me chat for an hour.
Thank you again, Ronnie. Everybody have a great rest of your day. See you around.